just recall the speaker bit rather than the questions. So when we get to the Q&A, the recording will be stopped, so you can ask whatever you like, of course. So a big welcome to Katie Johnston and Lisa Dafydd, who both specialise in employment reward and immigration at Silkin. Send us questions and suggestions via chat throughout, and I'll look after all those, and we'll have a good Q&A in roughly about the last 15-20 minutes, something like that. And we'll have a hard finish at 12 o'clock. So please put yourself on mute for now if you haven't already. Thank you ever so much. And Katie and Lisa, welcome, and over to you.
Thanks so much. Nice to meet you all. Thank you for joining. So as you know, you're all, I think, muted already. So if you've got any questions, then use the chat function, as Richard just said. If there are lots of the same topic that we pick up on, then it may be that we kind of round up at the end and do that. And it may well be that we discuss some of them as we go along. So it's probably best until we wait until the end and we'll pick up those questions. So I'm Lisa Dafydd. I'm an associate in Silkin. I'm joined by Katie Johnston, who's a senior associate in the same team, an employment team in Silkin. So I've done this session a couple of times already over the last 6 or 7 months. And every time I do it, then it changes, because as you can imagine, there has been changes to the law, changes to the guidance, changes to how society and attitudes kind of evolve, and even changes to the virus. And so hopefully at this point, we've caught up with where we are for today. It may be that things change in the future, of course, but also just to flag that returning to the workplace, it involves a lot of healthcare law and guidance. And so this is devolved within the UK. So there might be slightly different approaches within the UK. So Wales and Scotland might have a slightly different approach to England. This session is focused mostly on the English approach, but where applicable, we'll mention the differences when we can. Okay, so Richard, if you can go to the next slide, please.
Sorry, everyone. Sorry, wanting to move.
I'll just explain a little about the next slide is just a quick highlight of what we're going to be covering. So Katie will cover returning to the office and testing a little bit. I'll discuss employees who don't want to return for various reasons. Katie will then look at flexible working requests. And then I'll look at employment contracts and how we can tailor these a little bit for the future if we want to look at hybrid working or any of the changes that may have come in during the last 18 months. So if we go to, there we are. So this is for Katie to kick us off with a section about testing and vaccinations. Is that the right slide, Katie?
It is. Thanks, Lisa. And hi, everybody. So kicking off, this is actually where there is a slight difference between England and Wales. So as of the 19th of July, it's been kind of back to the normal message. There's no longer been instruction to work from home if you can. And so technically employers could say, right, everybody back. Of course, not everybody has done that, but employers need to consider the government guidance on working safely during COVID when they bring their workforces back. Now, the government guidance isn't the law, but it's likely to be the minimum that they need to do really to comply with the law. The government has issued 6 separate guidance notes for various sectors, so they've tailored it for different areas. So I won't name them all. But one is for offices, factories and labs, one is for restaurants, bars and pubs, one is for shops. So there's different approaches. Wales, the position is different. So since the 7th of August, their system has been downgraded to 0, but the advice remains to work from home if you can, which I think is quite interesting. You'll see there's a link on the slide where we've prepared some FAQs for returning to work and managing a safe return to work, and there's a lot of material in that, so we'll circulate the slides afterwards and you can have a look, and we update those really regularly to make sure they're up to date. But the FAQs cover things like how the self-isolation rules have changed. So I'm sure probably you are already aware, but since the 16th of August, fully vaccinated people don't have to isolate if they come into close contact with a COVID case. So obviously that helps employers in terms of, bringing employees back to the workplace. The FAQs also cover how to conduct a risk assessment before bringing your workforce back and the factors that should be considered. That risk assessment is likely to consider the impact of the vaccination rollout, which we'll come on to. The fact that since 19th of July, there has been this lifting of restrictions, and so there's been a lot of mixing. The FAQs also lead you to the guidance published by the Health and Safety Executive, which provides some kind of useful guidance on how to do that risk assessment, and also provides some practical measures that employers can take. Some of the things that they suggest are not really rocket science. So, adequate ventilation, sufficient cleaning, good hand hygiene, limiting the number of employees that come into contact with one another. So employers may, stagger start and finish times, for example. They may have a rota system so that not too many people are in the office at the same time. All those sorts of things. The FAQs also talk about what happens if employers don't comply with the government guidance. What happens? Well, just in summary, they may receive claims from employees or third parties if they contract COVID in the workplace. Question how they prove that, but that's another thing. But also if the employer's handling of the return to work leads to stress-related illness, for example, that may also lead to a claim against the employer. Also, of course, if employers don't stick to the government guidance, it may make employees more reluctant to come back to work, which Lisa will come on to. The FAQs also just touch on face coverings. There's no legal requirement to wear them, but the government guidance says that employers should, still consider encouraging the use of them in the workplace, especially in closed and crowded spaces, which, naturally makes sense. But of course, any requirements on masks should be subject to reasonable adjustments from disabilities or other medical exemptions. Can we have the next slide, please, Richard? So covering testing first. So testing is obviously an option for employers, hoping to encourage people to come back in as safe way as possible. But the issue leads to some interesting questions, and we've popped 4 of them on the slide. So the first one is, can we make asymptomatic lateral flow testing mandatory? Yes, the answer is yes, but it does carry some risks that employers should be aware of. I guess arguably employers are probably in a stronger position to do that now social distancing has been lifted and mask wearing has legally been lifted. And as we know, lots of people with COVID just don't have any symptoms. The government guidance is silent. It doesn't give a firm view about whether employers should test their staff. But interestingly, it does seem to give a slight hint, because in the guidance, you remember I said there were 6 guidance notes for different sectors. In the guidance for events and attractions and the guidance for hotels and guest accommodation, only in those guys does it say that employers should consider asking their employees to get tested regularly. So maybe that gives a hint where they think it's most important. I think, reasonableness of requiring testing will be linked to the nature of the business naturally. Does your business have, particularly vulnerable people, vulnerable customers, for example? But if you do require testing, what are the risks? And I guess the real question is, what do we do if an employee refuses? Could you let them work from home for a bit? May not be possible. Do we let them have some unpaid leave for a bit? But this virus doesn't seem to be going away, so that doesn't seem to be a sustainable option. If you were to go so far as to dismiss someone for not complying with the testing requirements, then they could potentially bring a claim for unfair dismissal, if they've got 2 years service, of course. But then it would be up to a tribunal to assess the reasonableness of that employer taking that decision to dismiss. We don't have many COVID particular tribunal decisions as of yet. Some tribunals have said that dismissals will be fair where employees refuse to carry out with employers' safety measures, as long as there's a clear rationale and it's being communicated. So it's possible to defend a tribunal claim. What about discrimination claims? Well, I think the risk is significantly lower there, because it would be hard to think of any religious objections or disabilities that, you know, prevent testing, for example. You could exempt double vaccinated employees from the testing regime, one option, but obviously that would disadvantage those who have not been able to have that vaccination for one reason or another, you know, for a medical reason, for example. There used to be a potential age discrimination issue here, because obviously the vaccination rollout has started with the older generation and made its way down, but, you know, obviously that's less of a risk now. In summary, it may be better to just, you know, make the testing, you know, voluntary rather than mandatory, perhaps. Moving on to the second question, can we insist on employees taking a PCR test if they have symptoms? Well, this is easier to do, isn't it? Because they've actually got symptoms, and the government guidance says, you know, anyone who develops COVID symptoms should definitely self-isolate and take a PCR test. Nothing's changed in that respect. You've still got the same risks in terms of if they refuse, you know, just unfair dismissal, discrimination claims, but I would say, you know, the risks are really pretty low in that respect. Can we insist on taking electronic temperature readings at entry points? Well, that's a lot less invasive, isn't it? Not as uncomfortable as testing, but you'll still need, you know, employee consent. You can't just, you know, randomly use your temperature gun at the door without getting somebody's consent. Like testing, it may be better to make it just optional. You know, and you'd imagine most employees would comply if you did ask them to do that. But there is a question of effectiveness, I guess, because of course it won't pick up asymptomatic cases. And then the last question on the slide is just in terms of, you know, what data privacy issues arise. Well, of course, if you're using vaccination data to show that they don't need to be tested, or you handle their test results or their temperature readings, this is health data, which is special category data under the GDPR. So as an employer, you'll need to conduct a data protection impact assessment before you process that information, and ensure you as an employer are satisfied that you're processing that data to comply with a legal obligation. Now, you know, that's pretty easy because you'll say, you know, you're complying with your health and safety obligations, or you're doing it in the public interest to minimize the spread of COVID. So I think, you know, you'll be pretty safe there. There are specific things you can do to minimize data protection risks. And I would just invite you to look at our FAQs for more information, which, as I say, are on the screen for you to have a look at when you get the slides. If you're going to implement testing, I would definitely recommend implementing a testing policy, and, you know, make sure you keep those risk assessments updated. Can we have the next slide, please, Richard? So vaccinations. Now, this is more obviously the controversial topic. In the UK, I'm sure you'll probably agree, we've seen a pretty impressive rollout of the vaccine. There's some facts and figures on the slides. Now, generally, the vaccine is not mandatory, although from the press, you'll probably see there is an exemption coming. So from the 11th of November, all people working in a care home for adults will need to be double jabbed, unless they have a medical exemption. And the government is in the middle of a 6-week consultation, considering whether that should be extended to all NHS staff and care workers. So, you know, that will be an interesting one to keep an eye on. As you can see from the slide, there are some more FAQs on the vaccination itself, and the FAQs cover the questions that we're going to look at now, go into quite a bit more detail than I can in the time limits I have. So have a look at those when you can. Can I have the next slide, please, Richard? So mandating the vaccine, can you do it? Well, it's not being tested in UK law. It's a really obviously interesting legal question, but we just don't know the definitive legal answer. And, you know, cases will start to come up. But we just don't know at the moment. But in terms of what can we do if we mandate the vaccine and the employee refuses, can we discipline them? Can we dismiss them? Well, I guess disciplining them won't really work, will it? Because if they're just given a first written warning or a final written warning, they're still in the workplace, I guess, unless it makes them go and have the vaccine. You could potentially allow them to work from home, but is that going to cause resentment? Is that sustainable? Ultimately, if you had to dismiss them, you'd have the unfair dismissal risk if they had over 2 years service, or potentially a discrimination claim from those with protected characteristics who cannot have the vaccine. As I mentioned earlier, if you're a care home, it's pretty straightforward if people refuse the vaccine as of the 11th of November, because there's a piece of law that they can point to and say you're dismissed because of this. But for everybody else, for all the other employers, they won't have that. So they would need to have a fair reason to dismiss that employee who refused their COVID jab. Do we think that they can do that? Well, if the employer can show that they've carried out a risk assessment and they think having the vaccine is the most reasonably practical way of mitigating the risk of COVID, then we think on balance, the vaccine could be seen as a health and safety requirement to protect both the individual and the colleagues around them. And so arguably the employees who refuse the jab could potentially be dismissed for a health and safety breach. Even if it's not likely, even if you couldn't go that far and say it's for health and safety reasons, they may be able to say that, nevertheless, it's reasonable in the circumstances for the business. And naturally, like with testing, it's going to depend on the nature of the business. If you, service particularly vulnerable people, it might be easier for you to mandate the vaccine. Can you use customer confidence? If you can say to your customers, oh, well, all our staff are vaccinated. Can you use that as a reason? It's unclear if that alone would be sufficient. But if you tag it with protecting against infection and achieving herd immunity, then potentially. But like I say, it's a really interesting and untested area, and we'll need to wait for the cases to trickle through. Should I make exemptions for medical, pregnancy or belief reasons is the next question on the slide. Absolutely, otherwise you'll be at risk of discrimination claims. We haven't got time to go into the detail about what discrimination claims may be possible. It's all in the FAQs. But interestingly, the only publicised recommendation to avoid vaccination on medical grounds is for those who have had a serious allergic reaction to the vaccine ingredients. No other publicised exemptions are made, but of course, people with disabilities, their doctors may have their own views about whether the vaccine, should be given or not. There is an interesting question about anti-vaxxers and in discrimination claims. So, if somebody was, very anti the COVID jab and they were dismissed, could this amount to a belief protected by discrimination law? And the answer is possibly. Again, not been tested, but it would be, an interesting claim if someone were to bring it. What about new employees? Well, the risk, of course, there is less than existing because you won't have to dismiss anyone. You're just saying, unless you have the vaccine, you're not getting the job. So there's no risk of unfair dismissal claims for new recruits. But, you would still need to be careful about discrimination claims. Can I have the next slide, please? So what's the alternative? Can we strongly encourage an employee to have the vaccine? Absolutely, nothing's stopping you doing that. Public Health England has issued guidance for employers explaining why employers should encourage the vaccine, and they've offered some guidance on how you can encourage. So some examples they give, sharing information on the facts around the vaccine, signposting employees to experts who are promoting the vaccine, allowing employees paid time off to get vaccinated, and publicising senior leaders who've had the vaccine. They're all examples that they give. The other question on the slide, can we offer incentives to get the vaccine? Potentially, yes. We're not seeing it much in the UK, if we're honest, but I think it's generally because the take-up's been quite high. But we are seeing it quite a bit in the States because we advise a lot of clients in the States. Incentives could be, vouchers, cash, or just simply allowing someone to take time off to get the vaccine. But I think we would strongly advise, just trying to promote the benefits first before turning to incentives. But equally, incentives is much less risky than mandating the vaccination. Can we get the next slide, please? Just quickly touching on vaccination information, can we require an employee to confirm their vaccination status? Possibly, but it's probably better just to ask them to tell you. Either way, you're collecting special category data that we've talked about, in terms of there are data protection issues to consider. The Information Commissioner's Office in the UK has said that if there's a good reason to collect vaccination status, then it's fine, it's a lawful basis. The position is different in Ireland, interestingly. They've said there's no legal basis for collecting vaccination status under the GDPR. So generally, it remains open for UK employers to ask. And do we need a vaccination policy? Absolutely. If you're offering incentives, or unusually if you're requiring employees to have the vaccination, we would definitely recommend a policy, and that policy should explain and communicate your approach along with the terms of any incentives. And just one last thing to say before I pass over to Lisa, a vaccination policy may also help to handle workplace disputes, because obviously the vaccination is quite controversial among some people, and different people have different views about it. But in that policy, you could consider requesting employees not to ask one another about their status, and failure to do so could amount to disciplinary matter. And you could also say that if any employees are spreading vaccination myths, then they could also face disciplinary action, and outline that in the policy. And now I think I'm handing over to Lisa, who's going to talk about employees who refuse to return.
Well, thanks so much, Katie.
Problem.
Okay, so we'll go to the next slide, please, Richard. So the first group of people we're going to look at are disabled employees. So you owe a duty of care towards any vulnerable employees. And as the government guidance has said all along, this involves taking a bit of extra care. So many vulnerable employees will qualify as disabled for the purposes of the Equality Act. So this means that they have the right to reasonable adjustments, which could potentially include staying at home. We still don't believe that this would extend to a right to stay at home on full pay if they can't work from home. So that's a useful thing. It's also unlawful to operate provisions, criteria or practices, so you might have heard of the PCPs, which would put these disabled employees at a disadvantage compared to non-disabled employees, unless it's justified. So, for example, a policy of requiring vulnerable people to return to work could potentially be indirectly discriminatory, and you'd need to have justification. It may be hard to justify requiring an unwilling vulnerable person to come back to work. If, for example, other employees could cover the role, or you could recruit temporary cover. But as things are changing, as people are going back into the workplace, that'll become less of an issue. It's very likely. Another thing to consider is incentives. So Katie's just discussed incentives to do with vaccinations, but incentives for people to come back to work. Just be aware, if you do this, but a disabled employee can't come back for whatever reason at that time, then they can't avail themselves of that incentives if they don't feel safe to return. So just be aware of any discrimination potential there, and just make sure that you can justify what you're doing. Possibly considering incentives in a different way so that the disabled people are able to avail themselves. Finally, just remember that some of your employees may not have a disability themselves, but may have partners or dependents at home who do have a disability, and who you're then concerned to protect as well. So the Equality Act protects these employees from discrimination by association. So do make sure that if an employee explains of this kind of situation at home, any circumstances like this, then you don't treat them any less favourably. Okay, to the next slide, please. So pregnant employees are treated differently than other vulnerable people anyway, before all of this happened. And they may have a greater claim to be allowed to remain at home on full pay during this time. So before, obviously, we were able to avail the furlough scheme. That's not running anymore, so we need to think a little bit more creatively. So pregnant women we look at different categories of pregnant women. So pregnant women with heart disease have been included in clinically extremely vulnerable individuals who must not go to work. So all of the pregnant women have been included in the list of clinically vulnerable people as a precaution, and are advised to be particularly careful about safe distancing, etc. Again, when COVID hit, the risks were unclear. Things are becoming slightly more clear now. So there's constantly updated guidance, and it's definitely worth checking with the person herself to see what her doctor recommends, because every pregnancy is very slightly different, and it's worth tailoring a little bit to what they can do. So for those under 28 weeks, the guidance was that you should do the usual workplace risk assessment and possibly involve occupational health, and then only continue bringing them into work if the risk assessment allows you to do so. So not unlike what you would do anyway, but just with the extra in light of what's going on at the moment with COVID. For those over 28 weeks or with underlying health conditions that may put them at a greater risk of illness from COVID-19, then the employer should ensure that they adhere to any guidance on social distance, etc., and any advice for pregnant women considered to be more vulnerable than usual. So again, check the guidance at the time, check with the pregnant person to see if they've got any particular guidance or advice from their own doctor. This may require working flexibly from home in a slightly different capacity, and you should even consider if you can redeploy these staff if it's difficult for them to work from home. Where adjustments are not possible and alternative work can't be found, then the guidance still says that the employee could be suspended on paid leave if that is the only option. Okay, so employees with no childcare. So this is the slide that's changed probably one of the most since I started doing this session, because when the schools were completely closed, it was a very, very different ball game. So things have improved a lot now. Schools are fully open. Many employees will find their childcare problems a lot less of an issue once they return to the office. However, there may still well be some issues because children are being sent home from school quite frequently for COVID-related reasons, or sometimes the childcare provision, so the nursery or the school classroom, for example, may have to close, again, for COVID reasons, for people who are isolating or sick staff, for example. So it's still worth being live to this issue. So if an employee can't get access to childcare, there are still some options available. If they can't work from home, then they have the right under the family-friendly legislation to take unpaid parental leave if they've got a year's service, and that's 4 weeks per child. Equally, they may be able to argue that they need a reasonable amount of time off to care for dependents, and ordinarily we'd say that this is limited for slightly more emergency reasons, so to allow the employee to look for an alternative provision of childcare. But just be wary of this, because again, it's not one of the things that's been tested very much, if at all, in the ET, but we anticipate that the tribunals will be sympathetic to employees who are genuinely finding it difficult to source childcare this time. Okay, so the next slide, please. Okay, employees who just don't want to return. So there might be a whole host of different reasons for not wanting to come back. So duty of care remains, and be careful that you haven't missed anything out when you're discussing, what's going on with these people, any potential disability or any other issue. You could potentially take disciplinary action against employees who, when you're completely confident that you're taking all reasonable, practicable steps to control the risk of transmission. However, there are obviously risks to taking this approach, and especially given the lack of case law indicating how tribunals would approach fairness of such dismissal. So any dismissal could be regarded by the ET as unfair and disproportionate in the current situation, and disciplinary action could result in constructive and fair dismissal claims. So that's really the kind of last resort, really. Furlough is finished, so that's no longer an option, and it's worth having a frank and sensible discussion with the employee to explain that the guidance for vulnerable and extremely vulnerable people has now changed. So that's one of the things we've had quite a lot of queries from clients, of people asking, saying, look, I was in this category, I was told I had to stay at home, or that I couldn't go to work, or I shouldn't go to work, you know, does that mean I can't go back now? And often it's people who are just not quite sure what's going on, what's the best thing to do, as opposed to people who are just genuinely just not refusing to come back. So having that discussion is really, really useful. Find out exactly why they're worried. Sometimes people just want the reassurance that you as the employer have taken all the steps that you should have. So Katie mentioned things like risk assessment, ventilation, social distancing, any kind of tracing system that you might have. If the employee thinks they're not well enough, then there's obviously still a chance of some vulnerability to the virus. Then it's a good idea to ask for a bit more information, so maybe a letter from the doctor or even an appointment with OH, because with this in mind, you might be able to make a few tweaks, and that might be enough to alleviate what they're worried about. So for example, some people were worried about commuting on a busy tube. Well, changing their or staggering starting and ending times of the day, that might be enough to should make them feel confident enough to come in, and they don't mind actually as long as they're not in a very busy carriage, for example. If employees can continue to work from home, you might agree that they continue to do those whilst going through the next steps of finding out how best to get them back. We've found that the more people who come into the office, the more reassured everybody becomes, because it becomes a bit more normal, and it takes a bit of time for everyone to get used to coming back and having a bit of new normality. If an employee still can't work from home, then a cautious approach would be to offer unpaid leave. Employees who are not able, ready and willing to work are not entitled to pay. So if they're just refusing to come in, then they don't get paid if they can't do the work. While seeking to reassure the employee that you're complying with the workplace safety guidance, you need to consider offering support, even think about mental health support, well-being, and encouraging them to come back into the workplace. Again, what's important is ascertaining the reason that they don't want to come back. So the anxieties that people may have developed during this time, then just to make sure that you are offering all the support you can without forgetting that there may be some disability potential risks here. Okay, so we'll go to, right to the bottom of that slide just before I go. Again, more links to quite useful FAQs and articles. Richard is going to send out these slides after the talk, so you can have a little look. As Katie mentioned at the beginning, these are updated, so even though you'll get them today, if there are changes in a month's time, then these things will be updated, so you'll get the most up-to-date and recent guidance. Okay, so I'll pass on to Katie to talk a little bit through flexible and home working now. Thanks, Katie.
Thank you, Lisa. So, in the post-COVID world, probably, employers are going to probably get a lot more flexible working requests than they did. So we thought it would just be, helpful to talk about this topic. You'll probably all be aware that currently only those with 26 weeks service have the right to make a flexible working request. Of course, that doesn't stop employers considering one made earlier, but that, is the law. They could, legally refuse if they've been employed less. But arguably, that sounds quite updated. And, we were talking before you all joined us, Richard, Lisa and I, how quickly employment law moves. And I think this is a really good example of this, where, the pandemic has just made it, really outdated that you need 26 weeks service. So there's been a lot of lobbying from protest groups about this, and the government are currently considering whether to make it a day one right. And I understand the government consultation ends on the 1st of December. So it'll be interesting to see what happens there. But, in the current regime, you need 26 weeks service. So as an employer, when you get a flexible working request from an employee, you obviously have to consider it. You have to have a meeting with them, discuss the reasons, go through all of that fair process. But at the end, you can refuse the request for limited statutory reasons. But you need to bear in mind that refusing a request from a protected employee could lead to discrimination claims. So, for example, if they need a flexible working arrangement because of a religious requirement, for example, that if you refuse that request, then it may lead to a discrimination claim. And, interestingly, that can occur even before the 26-week period, if you see what I mean. So even if somebody requests before the 26 weeks for religious reasons, that could still be a discrimination claim, even if they've been employed for a shorter period. But typically discrimination claims arise where women make flexible working requests for childcare reasons. They'll go on maternity leave, come back, and they'll make a flexible working request to work a different working week. And unreasonably refusing that request could lead to an indirect sex discrimination claim. So nothing's changed in the context of being careful of discrimination claims. But what grounds do you have for refusing, bearing in mind those discrimination risks? But other than that, what grounds can you refuse requests on? Well, there are some statutory reasons. And these things include things like additional cost, the inability to reorganise work, and the impact on quality or performance of the job. But just please remember that additional cost alone is not sufficient. So sometimes people want to reduce their hours slightly, and the company will say, well, we just can't afford to fill in the gaps with an agency worker or something. But cost alone just won't work. So that flexible working regime will still continue to apply, and employers have to make sure they go through the process and give good grounds for any refusals. However, flexible working has changed significantly in the past 18 months. And can we have the next slide, Richard, please? And I guess flexible working in the future can be, is possibly something quite different to what we've been used to. So I think we need to think about, this in the context of the new normal, post-COVID, because a lot has changed. And, what will it look like when offices reopen? Some businesses may find that remote working was a success, with a complete remote workforce. It worked well. There were obviously a few issues to straighten out at the beginning, but, when businesses got into the flow of things, then, complete remote workforce actually work quite well. But then it may cause issues when offices reopen. For example, needing to schedule for virtual meetings alongside physical ones may be difficult, or the logistics of managing office space may be difficult, or having fewer people in the office with the burden of the mundane physical tasks while other people are at home. So it may be actually easier to manage a more flexible working model where people split their time between home and the office. But it's going to be an interesting one in terms of how many requests you get and in what order, that sort of thing. And of course, comparisons will be made with last year. Like I say, some things will have worked well, some things will have been more difficult. All of those things will come into play with any flexible working requests you receive. People have adjusted and will want to probably work from, some employees will want to work from home more, and so they'll probably be drawing comparisons with last year quite a bit, and may point to really good tangible results, for example, to say, look, I can work from home because of XYZ. And so it'd be quite difficult, I think, if an employee has worked from home really well and it hasn't affected their tangible results, and it'll be quite difficult for the employer to refuse a request on that basis, because they've been doing it for a long period. It's not like they've been working home for a week or a couple of months. So employers are going to have to think really carefully about what other reasons are key for wanting people to come into the office, and we'll touch on these in a bit when we come on to some key questions. But I guess, different employers will want different things and they'll have different requirements. But, the key may be to cherry pick some of the positives and, form a hybrid model of some kind. Can we go to the next slide, please, Richard? In terms of flexible working request best practice, I'm sure, you're fully equipped to deal with a flexible working request, but we thought it was just helpful to remind you of the key points. Consistency is really important, as I'm sure you're aware. Have a clear centralized process for dealing with the requests. It's quite risky to leave individual managers to make their own decisions. Employers should always consider the requests in the order they've been received, and consider them positively, and if something can't be granted, then explore alternatives or compromises that might work instead. Be mindful that, you know, things that may have worked during the pandemic, for example, you know, working while looking after children, may not be something that you want to, you know, rubber stamp going forward. And so you need to be clear about those sorts of things. Trial periods are often used when flexible working requests come in. They've not actually ever formed part of the flexible working kind of law, but it's still open for employers to agree, you know, to a trial on that basis. Some might say, oh, well, you know, we've trialed it, you know, I've done it at home. But again, you know, we're in different territory now with more people coming back to the office. So I think as an employer, it's perfectly acceptable to say, well, no, we need a trial now when more employees have, you know, returned to the workplace to see how it works now. If you want to implement a trial period as an employer, you just need to make sure you've got a few things in place. You need to make sure, you know, you're clear on the period, when it will be reviewed, and, you know, how success or failure will be determined. In some cases, you know, trial periods, especially now once people have come back to the office, you know, it might be a useful tool to show that, you know, you as an employer were willing to consider the change, but to provide evidence as to why, you know, it won't work in the longer term. There's a question on the slide that says, you know, can't we just say, well, we'll all work flexibly now? Is that not the answer? I guess that's tricky because, well, what do we mean by flexible and flexibly? Because it's more than working from home. I know there's obviously been a lot of spotlight's been on working from home, but flexible working also covers, you know, reduced hours, compressed hours, fewer days, all those sorts of things. So I think it's difficult to just say, oh, let's work flexibly. Employers need to have some, you know, parameters in place about what flexibly means. We don't have time to talk about working from home abroad. That's a whole new session in itself, but there is a link on the slide to our article about it, and I really recommend you take a look when you can, because there are some real traps that employers can fall into, and some, you know, quite significant issues, including tax, for example, if you get it wrong. So we really suggest you have a look at that if you have the time. I think we're just going to move on now to a few FAQs on flexible working, and Lisa's going to just cover the first three.
Still muted. You'd think after almost 2 years of doing this, I would remember to unmute. Anyway, so we're looking at a couple of flexible of FAQs that we've collected over the last few sessions that we've done of this, because it may well be that these are the similar kind of questions that you have. So let's look at the first one. So can we postpone or extend a trial period until after the lockdown so that we can make a proper and fair assessment of how the trial's working out? So the principle is that if you, the employer, and the employee have agreed a particular trial period, then a fresh agreement is needed to vary this. In this case, you, the employer, should consult with the employee, and to be honest, an extension is likely to be really beneficial to the employee, because it means that the flexible working arrangements will be in place for a little bit longer, and they've got a better chance to show if it can work, and it's obviously useful for you too. It's worth bearing in mind that obviously that the lockdown has now finished, but the situation where, you know, we're still not back to completely normal, and it may not be that we are ever really back to a complete normal. So extending the trial period is still useful, because it still shows how efficiently people work, and whether it actually works for your business. One of the things that might be useful to think about are, when you're considering things like flexible working, you know, the trial periods, are to take a little bit of a feedback log. So whether this is from other colleagues or from clients, because one of the things that's really difficult to kind of measure is how effectively people are working from home. And so it's probably worth just, you know, if you are getting any feedback from clients or colleagues, just to say that, you know, it's working well, or if people are not around at particular times, then that's useful. So when you do have these review meetings, then you can discuss and kind of address those issues. Okay, so the second point, at what point does it become reasonable for us to say that we have too many employees working from home? Unhelpfully, there's no real fixed point in law or in the guidance as to when you, the employer, can say that you're unable to accommodate any further requests. So it all depends on the business and how efficiently you work in this way. So the short answer is, Each request is to be considered on its own merits, and to consider them in the context of what's happening for that employee and for the business as well. The third one, so should our managers be proactively asking their teams if they intend to make flexible working requests, and so that you can consider them in the rounds as a group. So there's clear guidance from ACAS that requests should be considered in the order that they're received, as we've mentioned earlier. So not necessarily that the first request will be accommodated, but that you consider them in that order. And this keeps it, this is kind of quite a fair way of allocating the priority. So this is likely to be helpful for you as employers. The downside, of course, of inviting all requests by a particular date is that you then have to consider them in the round, and you can only likely to be able to agree some of the requests and not others. And then you're in the position of having to identify a clear non-discriminatory reason for choosing some requests over the others. Okay, Katie's going to look at the last two questions for us.
So I think this links to what I was saying earlier. So won't our company culture, team working, employee wellbeing be impacted by home working? Can we take these into account when somebody requests to work from home? So remember earlier I was saying that some people will say, well, look at my results. You know, I've been working from home, fine. You know, I can work from home. You know, company culture, team working, employee wellbeing. These may be some of the other reasons where the employer says, well, actually, it's not just your results that are important as part of your role. You know, all of these other things are important, you know, especially if the individual is needed for supervising others, for example. So they can be taken into account if somebody makes a request to work from home, and they might be quite important reasons, you know, to try and bat away a certain request, or, you know, to modify a request in some way. You know, it may be that you can't accommodate working from home 100% of the time, but, you know, maybe partially, for example. And the last question, if we introduce a new hybrid home office working model, would everybody need to submit a flexible working request? No, not necessarily. If you're changing the contractual place of work in the contract, or, you know, the office hours in the contract, then you'll need to consult with them in the normal way and get that consent to amend that. But generally, you wouldn't have to. If an employee they wanted something different from the norm, then they would need to make a flexible working request. And so I think those are all the FAQs, and I think Lisa's just going to quickly touch on contracts before we end for questions.
Yes, I'll try and skip through this quickly because I'm aware of time, so we've got time for questions. So employment contracts for home workers. So this brings with it some new questions that you need to consider and how to formalise these. Do you leave it flexible and update your home working policy, or do you need to, in some instances, to record a new home worker contract for existing or new employees going forward? So a home worker contract is going to be necessary for some employees whose place of work changes completely to their home address, but there are still some number of things to consider as the employer. So place of work, for example, are you happy for the employee to be permanently at home, or do you want to build in a little bit of flex about requiring them to come into the office for meetings, appraisals, training, etc.? Consider expenses. Do you are you happy to pay expenses for people to come into the office, or is that considered to be the normal commute? That's something you need to think about, and that would need to go into the contract. Another thing is to consider, if you are going to pay expenses for people to come in, some employees who may have chosen to move away from the office for quality of life purposes, they might have a very long commute. So some people, so for example, we've got one client who's one of the employees have moved to Scotland to live, and there's no problem at all working remotely from there. But actually, the expenses of getting that person down to London for meetings is quite significant. So it's about having that discussion and deciding in advance what happens. Home working has its advantages for employers, but employees need to be cautious about the practical effect that might disadvantage certain groups. So for example, if some people have a lack of access to internet in rural areas, some people may live in shared accommodation, there may be caring responsibilities or financial issues or any other circumstance that makes it more difficult to work from home. So just bear that in mind if you're asking people to work in a hybrid way. It might be not that easy for some people. Diversity and inclusion policies should extend to home working, and employers should invite and encourage employees to make any disadvantages known so that they can make these reasonable steps to help them. It's a good idea to involve employees in these discussions. It's never a bad thing to open up about options that you have. It empowers the employees to be part of that conversation and the decision-making process, and it gives them an opportunity to express any worries and difficulties so that you can consider how best you can make it work for them. As mentioned, disabled employees are may be entitled to auxiliary aids as a reasonable adjustment under the Equality Act. So if such an aid is reasonably needed to work from home, then you might consider footing the bill for this, depending obviously what it is. Okay, and that brings us to the end of our session. There's another link at the end of that, of course. I can see that there are 2 questions. Richard, I think you were going to end the recording there, is that right?
Yep. Give me just a sec. I just want to say thank you ever so much for taking us so thoroughly through what is obviously a very emerging area of employment law, and that's moved so very quickly. So let's just